Yes, now it's
Okay. Hello, everyone. I am Arzoo Osanloo. I'm the director of the Sharmin and Bijan Mossavar-Rahmani Center for Iran and Persian Gulf Studies, and this is really my genuine pleasure to have a conversation with my good friend and colleague Arzoo Osanloo today about her book. Which I'm going to introduce in a bit, after introducing Arzoo to you. Arzoo is a legal anthropologist and associate professor in the Department of Law, Society, and Justice at the University of Washington in Seattle. She has also affiliation with anthropology, women's studies, and she's also director of the Middle East Center there. Professor Osanloo is not a stranger to Princeton. She spent a year in 2011 and 2012 as a visiting fellow at the Center for Law and Public Affairs. She earned her PhD in cultural anthropology from Stanford University in 2002. And before pursuing her PhD, she was a practicing attorney specializing in immigration and asylum laws with a degree from the American University School of Law in Washington, D.C. I got to know Professor Osanloo after reading her amazing book, The Politics of Women's Rights in Iran, which was published in 2009 by Princeton University Press. She has very strong ties with Princeton University. and and I used this book in any way possible. That any course I teach, I try to use this book because it's one of the prime examples of looking at the way women in Iran had engaged in politics in public sphere and their own understanding of the concept of rights and how they draw from hybrid sources of understanding what rights are and how they engage with those conceptions, from Quran reading classes to law offices to schools to all different public places that women are engaged in Iran. And so if you haven't read that book, I strongly recommend that book to all our audiences. Of course, today we are going to talk about her second book, which is hot out of the press, Forgiveness Work, Mercy, Law, and Victims' Rights in Iran, also Princeton University Press. I'm not going to say anything about the book because Professor Osanloo is going to talk about it, but I just need to just mention one thing that is really attracts me to her work, is that whatever I read of Professor Osanloo's work is something that is so clear, that is written with such care. And I use care in both senses of the word, care as something which is done with diligence, it's nuance, it's very careful, and also it's affective. So care both in both terms, and both books, if you read it, especially the second book, that there are so many stories in it, and I'm waiting for the novel version of this book to come out soon. But this is a gift, and I think it's such an important element in Arzoo's scholarship, and so let's talk about your book and tell us what's in the book and how it came about, and then we have a conversation about the book. Here you are, Professor Arzoo.
Thank you so much, and thank you for inviting me. Can you hear me okay? Is the sound okay? Okay.
Yes.
as we started, I was telling you how I'm so nervous because it's being recorded, and I'm used to giving a lot of talks, but there's this sense that like I can't misspeak, I can't make any mistakes because it's being recorded. But just to forewarn everyone, I will misspeak, and you can go and read the book and find out what it really says. Can I hold up a copy of it?
Absolutely. Yeah, I have my copy too, so we hold up two copies. Problem with these backgrounds is that then you can't put the book. Oh, okay, here it is.
I know. There you go. I was going to use the book as my background, but I thought that would be just too cheesy. But yeah, thank you so much for inviting me. I want to thank the center, and I want to thank you in particular for not just inviting me, but as you know, your support throughout the years. For those of you who don't know, Professor Rahmani has been sending me amazing stories from the Iranian press of forgiveness work that has allowed me to sort of triangulate the research that I have been doing in Iran and the stories that I've been collecting over the years. So we joked that he was my research assistant and he should be paid for that. But the book actually, thank you for talking about my previous book. The book actually emerged as a set of ideas when I was actually doing the PhD research as a doctoral student for the first project. And what happened was that project, I was on my way during the month of Ramadan, which is important. I was on my way to interview someone about issues surrounding women's rights. And that day, everywhere I went, whether it was in the person's office, in another law office I went to that day, in the taxis, 2 different taxis I went on, I heard the news that this young man, they referred to him as Pesad, this boy, was going to be hung. And nobody could believe it. Everybody was beside themselves. And this during the month of Ramadan, when people aren't executed during the month of Ramadan. And what's worse, people started talking about the facts of the case that showed that, what he did was an accident. And this had legal significance because an intentional killing, qisas, or the right of retribution, is only the right in intentional killings. And the whole thing started to dawn on me that, wait, what right? Whose right? And I came to realize that the right belonged to the family of the victim. And suddenly, in the intervening weeks, the young man's case went through, he was arrested, he was convicted, the case went up on appeal, and it was confirmed. And finally, in the very public square where the incident occurred, where the murder occurred, there was going to be a public hanging. And it was all just very shocking. At that time, Ramadan was in the winter, and it happened to be December. And the sunrise and sunset it was much shorter. It was much easier to do the fasting. So I actually did it. And I would go over to my friend's house to break fast for the iftar, and we would wait for the azan. And one day I was at her house and we turned on the television wanting the azan to come on. And you know how before the azan, they sometimes have little stories. And suddenly we saw this man in the prison clothes with the noose around his neck, and he was begging for his life. Maro bebash, Maro bebash, he was crying. And then the cameras were panning to this public space and this group of like thousands of people. And it was sunset, and what we saw was dark. So we thought it was live. And we were watching this, and my friend literally told her 12-year-old daughter to go out of the room because it looked like this man was about to be executed, hung on public television, alive. And as the camera was spanning across the audience, the hordes of people, someone raised his hand like this and said, "Man mibakhshem," I forgive him. And we were like, what? Even my friend who, this was 20 years ago. By this time, the Islamic Republic was 20 years old. Even she was like, what's going on? And we realized that the father of the victim was foregoing his right of retribution. And he was able with that to stop the execution. And I became interested in this from the standpoint of my legal background, having gone to law school and practiced law. When I took criminal sanctioning in law school, we always learned that, well, it's, you never want the family of the victim to have the right of retribution because they want the revenge. They're emotional and they can't be moved. And so they can't be moved to not use execution, to not use violence. So the state has, that's another reason why the state needs to have that monopoly on violence, so to speak.
And the state is also the rational actor there.
Exactly. And so I thought, wow, this is kind of an amazing scenario to study what really is, I think, an extreme version of a victim's rights criminal justice system. Like what happens in these cases where the victims possess the right of retribution. And so I started to get very interested in this question of, wait, the family of the victim can forego retribution, but they don't have to. So who does that? Who would forego the right of retribution when the law lets them get their just deserts? I mean, lets them get their revenge, so to speak. Mm-hmm. In the book, I actually distinguish revenge from retribution. Revenge is the excess, actually, of retribution for a lot of legal scholars. But what happened the next day after that execution was equally interesting. And that is that the Islamic Republic used this scenario, including on-site interviews with members of the audience, members of the crowd, to ask about, like, what did you think about this? And people were so proud and people were so happy that they have their own version of human rights in Iran. They don't need the Western version. So you could see the way in which this justice system, this mechanism within the justice system, was being mobilized to make a statement about human rights and humanitarianism as well. And so I became very interested in the meaning of mercy and what that means in relation to the discourse of rights, because as you mentioned, my previous topic was rights discourses. Mm-hmm. So how does mercy relate to rights? And that a big part of the intellectual work of the book is to think about what mercy means in these contexts, because for some people, mercy is the antithesis of a discourse of human rights. And for some people, because justice systems all over are unpredictable and unfair, and we see that here in the United States, that mercy embedded within a justice system is actually more justice. Mm-hmm. So I'll say a little bit about how I got into the project. So that was, over 10 years ago, 20 years ago, but then over in the intervening years, I started to think and write about criminal law and mercy. And I was very interested in the legal right of forbearance. And what happened that was really crucial was that while I was conducting my research, Iran actually formalized for the first time since the revolution its criminal laws and the laws of criminal procedure. In 2012, the substantive criminal code and the laws of criminal procedure in 2015. And this is important because according to my interlocutors, the notion of forbearance, porangtar shod, was colored in. It was what we would say in legal speak is it was construed. It was mobilized in a way in the code that previously it hadn't been. So in my mind, after the revolution, the laws became very kind of, if you want, important for the state to establish itself as an Islamic republic. And so there was a lot of emphasis in family law and criminal law on instituting the Sharia. And I'm not saying forbearance wasn't a part of it, but the articulation and opening up of forbearance in the code started to take place much more after the revisions. Oh, they weren't really revisions, the formalization of the code.
Or codification process.
Yeah. I mean, I don't want to say that it's all formally codified, because one of the arguments of my book is that what's interesting about this is that you have the right of retribution and it is codified, but there are no like rules or regulations around how to go about getting the forbearance of this aggrieved, pained family. I mean, just think about, you know, what we hear about in the news, the family of Breonna Taylor or the family of George Floyd. Like, they're aggrieved, they're in so much pain, these families. So how are they supposed to come and forgive? So I became interested not just on the legal side, but I became interested in, if there's no rules, then what conditions have to be present, or what conditions come about for some families to go and forego their right of retribution. So what I argue in the book is that this codification of forbearance on the one hand, along with a very strong religious compulsion to be merciful and forgiving. You have this on the one hand, but then on the other hand, you have no guidance whatsoever on how to forgive. This creates a tension. And I argue that this is a productive tension. And a lot of actors get involved in this, I call it a cottage industry, with all of the implications of it's a market, of people who want to get involved in what I call ultimately forgiveness work. So I say that this productive tension creates this field. I call it a semi-autonomous field, and I'm drawing on a legal scholar, legal anthropologist by the name of Sally Falk Moore, to say that this semi-autonomous field is guided by the laws, but it's also guided within its own sort of informal rulemaking capacity. And so the way I looked at the book was, I thought the book would just be about the cottage industry originally. Like, I thought I would just talk to like these different actors that are involved in forgiveness work. But then, you know, the laws changed, and I started to get permission to go to the criminal court, and I met a lot of judicial officials, defense lawyers, prosecutors, and I realized the law, just like in my previous book, the law is a huge actor in this project. So the book is actually divided into two sections. The first part looks at the law, and the second part looks at this cottage industry where forgiveness work takes place. And if I can, I know you wanted me to talk for 15 minutes. I don't know if it's been 15 minutes.
That's good. I mean, it's so fascinating. I'm sure that everyone is enjoying this conversation already. So no, just carry on.
So one thing that I noticed, and I think is interesting in the first part of the book, which I just want to say, my husband, shout out to my husband. He's not an academic. He read the entire book. And he did say the first chapter is a bit heavy. It's legalistic, but it lays out what is a really interesting system that I call a crim torts system. And that's not a term that I coined. It's actually a scholarly term from academics in the United States who look at the ways in which the criminal justice system is picking up the private tort system. In Iran, it's the opposite. It's a tort system. It's a private system based on harm. And so it's a crim tort system, but it's the opposite in the sense that it's the family of the victim that holds the right of retribution, can decide the ultimate penalty, as opposed to the United States. So in the United States, if you think about it, we have murder cases. I always tell people, think about the O.J. Simpson trial, right? You had the state trial, the federal, the state of California trial, and they have the death penalty, but then they lost. And then there was the unlawful death suit. That was the private harm. That was the tort, that the unlawful death suit that the family brought. Now the family can get monetary damages, but they can't execute. So in Iran, it's the opposite. The family goes first, plus they can execute. And so that's the first part. I look at that system, where it came from, but I also look at the requirement in the code of criminal procedure on the part of judges to try to reach a settlement. And so I look at how that takes place, what the judges do, are they activist judges, how they go about this, and how they also have to sort of walk a fine line between being, impartial arbiters and at the same time saying, there's room for forgiveness here, kind of coddling or like sort of, what's the word I'm thinking of? Just like pushing slightly, gently, persuading the family of the victim to look at it differently. And so we look at some state actors as well. It's not just private actors who are involved in forgiveness work.
No, that's, there's so much in the book that one can talk about, and it's so layered. It's just, of course, the book, as you say, is 2 parts, but in each part there's so many layers of institutions, actors, and interpretations. They're both at this kind of discursive level and at the institutional level. And each of these levels, they have layers of their own. And it makes it so fascinating to just follow the lead in these kind of layers of different kinds of stories there. And I used stories on purpose here because there are so many stories there as well. And but what I really was taken aback by reading this, and possibly the reason I really like the book, both books actually in the same vein, is that you show how ambiguity and sentimentality is built into the system. And that's so counterintuitive and unusual, because if one is thinking about the law and codification, it's all about clarity and predictability and a routine and so on and so forth. But then here we have a system that brings in this kind of ambiguity and the very fact of affective institution as part of the way that the system operates, and that allows for different kinds of discretionary power, bringing in different kinds of actors into the story. But that part is I think, to me, it's so incredibly fascinating. And I'm interested in the notion of ambiguity because I use that in my own work to show the sort of discrepancy between formal institutional versions of things and the actual praxis of things, and how one should see the two at the same time together, operating with one another. So if you could talk a little bit about this kind of incorporation of ambiguity and sentimentality into this legal procedure, that would be really helpful.
Sure. The ambiguous nature of law is not something that's unique to Iran or Islamic law. It's actually legal scholars, Larry Rosen at Princeton, Max Gluckman way before him, have written about ambiguity as a way to allow for discretion. So this project took a long time. It took 10 years to complete. And in the process, one of the reasons why it took 10 years was because I was trying to gain trust with people who are deeply entrenched in the system and believe in it. And over the years, I would take my questions from my sort of Western legal scholarly friends or anthropological scholarly friends and ask the people there about some of the ambiguities. And one issue that I thought was a problem, like if I were writing a policy paper years ago, I thought, I would say that, this is an interesting system, but the fact that families of victims are not required to engage in like negotiations or have forbearance talks might be a problem. Maybe they should add some guidance. Mm-hmm. And all the legal scholars in Iran that I talked to said, oh, no. It's intentional. This space of ambiguity is intentional precisely because they don't want to co-opt what they believe is the legitimate right of the victims. The state is not the primary victim in these cases. The family of the victim is the primary victim, and they want to allow that openness. That it's part of it's been described to me as part of the healing process to hand over something that has been lost, to hand over some power is part of the process of making them whole. So to have the power to decide is part of the justice that they believe their system ensures and allows. Mm-hmm. And so the ambiguity allows for different kinds of responses to the right of retribution. And it allows for the crucial aspect of time to enter into the process of determining, what the decision is going to be. And time, the old adage, time heals all. Time plays a very important role in the process of getting families of victims to open up, to be willing to talk to people about their pain, to be able to process what's happened, to be able to envision a world without their loved one, but also a world in which they don't seek the ultimate penalty from the perpetrator. I don't know if that answers your question.
No, that's very, I think possibly maybe we can kind of unpack this a little bit more by looking into, I don't want to use the term schizophrenic, but maybe paradoxical role that the prosecutors and the judge play in this story, because that's also, I think, is very much linked to that notion of ambiguity there, because it's about roles, and what again really is fascinating is this kind of duality that the same people who are pushing for maximum penalty, for capital punishment, mm-hmm. And there are basically representing the retribution on behalf of the state and the victim's family, suddenly turn around right at the end of the process to play somewhat a role of the mediators between the victim's family and the perpetrators, and try to persuade victim's family, okay, now we accomplished what we were supposed to accomplish. We sentenced the person, the murderer, to death. Yeah. And now you come in, and your role is to forgive, and forbearance becomes the main kind of discourse. And that's a kind of a really, I mean, it's hard to wrap your head around that what happens literally in a matter of hours, that from verdict to the negotiation of for reconciliation that is led by the same people who pushed for retribution.
I write about this in the book, and I think schizophrenic is fine. That's actually, I use that term in the book, drawing from Aung San Ho's use of the term in his wonderful work, The Graves of Tarim. And it's interesting because it really asks us to consider the role of the judiciary in all of this, and the judges. And you know, it's interesting when I do my research, I always think that the judges are hesitant because they want to show themselves, they know I live and work in America, and so they want to show themselves in a certain way. But over the years, I realized the only hesitancy they had was by appearing that they preferred forbearance and looking like they were not looking after the paramount right afforded to the victims of retribution. And this question that you're posing me, it's really interesting because the lawyers, the defense lawyers, the forgiveness workers, the social workers that I write about, they all had this. They said to me the exact same thing. They said, oh, this judge is, all about forgiveness, but he's the one that handed down this sentence. Like, why did he do that? And I asked the judges that. I said, this is what people are saying to me. And they said, and I think, talking to judges in the United States, I don't think it's any different. They said, we have to follow the law. This is our law. And we have to make a determination on the merits of the case. And the merits of the case show that this was an intentional killing. This was the procedure. And this is our verdict. But once we do that, we also have a duty to become arbiters. So it is a dual role. It is a schizophrenic role. However, that role, that's why time is so important, because, and I have a story in the book that maybe you're referring to, where the judge makes very clear, like he's literally changing his hat. He says, we have handed down the verdict, the trial is over, but this case has room for forgiveness. And now we are moving into a different stage. We are now working on the myeonjigeri, the arbitration. Negotiation. Now, I think he said, this is a jalese solusazej. This is now a meeting for settlement and compromise, and or forbearance and compromise, whatever you want to call it. And the way in which the judges enacted that was almost physical, and I describe it in the book. Like, the judges are up on an elevated platform, and this one judge literally jumped down, like he was on the level with the people. Or in another case, the judge tells the woman, come and take a chair, sit next to me, let's talk. So they move away from the role as the impartial arbiter of fact and the fact finder to the arbiter. And they do seem to be very clear about that. They always raise it. I mean, I should say, always is maybe a bit of an overstatement, but in most of the cases that I sat in, even before the verdict, the judge always asks the family of the victim, what do you want? And they might say, I want qisas, nothing but qisas. But then the judge, and I should say, before the revisions, before the 2012 revisions to the law, it was a 5-judge panel that made the determination of guilt, handed down the qisas sentence. After they changed it to 3, they said there was too much of a backlog, it took too much time to process. And they need a majority of those 3. to go for qisas. And so the three judges, but are oftentimes, you know, all three are talking, and the chief judge, there's a chief judge who kind of runs the hearing, but they always say, again, always, in most of the cases I saw, you know, you can also forego retribution. You know, you can also take some time and think about it. You know, the retribution, the qisas is not going away. You always have that right. But why don't you take some time? What's going to change in a couple of weeks? Just take some time, think about it. So they always raise it, but
no, that's yeah. I mean, I really again, you know, it reminded me of the story of the judge who actually forgave the murderer of his own father, right?
Exactly.
That's the example that and on the one hand he talks with pride that he has handed down the most number of sentences, but on the other hand he himself, you know, forgives the murder of his own father, exactly because you said that, you know, he feels that he has to abide by the law as his in his role as a judge, and then but as a father, as a son, then
Yeah.
that's a different story.
I mean, we can even step back a little bit from the microcosm and say, what's in it for the state? I mean, the state wants to show that they can be very swift and decisive in delivering justice to victims of violence, so that victims don't take that into their own hands. So they can say, we will deliver you a swift judgment of, you know, retribution, but we'll take time to allow you to think about your right to forego that retribution. So the state wants to say, we're the arbiter of disputes, and we will protect the victim's rights. And that's all they see. They don't see themselves, I don't know if I can say this, I'm not sure they see themselves as committing violence. They see themselves first and foremost as protecting the victims of violence. And if they can't do that, then, you know, it's legitimate, you know, they control legitimate violence, right?
Yeah, no, that's so true. But I mean, there's so many stories that as you talk, I keep thinking about all these stories, you know, but I don't think we have time to go through all those stories. But one of the very important questions that you raise almost in every chapter, you can see that it's a question of gender, of course. I mean, this is such a heavily gendered process at all levels that you engage with this question. Can you talk a little bit about that how gender manifests itself in this process of forgiveness work?
Yeah. Yes, gender is very, very important. And it's interesting because, you know, sometimes as an anthropologist, you're not sure if you're talking to certain people because of your own gender and, you know, how things play out because of that. And anthropology has a long history of representing male voices because many of the anthropologists from 50, 75 years ago were males and women were left out. So I found that, gosh, in collecting these stories, a lot of the people I was talking to happened to be women. And not only did they happen to be women, but they were the ones that I was talking to them because their families had sort of selected them to be the deciders, to be the ultimate decider, because it has to be a unanimous decision by all the most intimate family relations that have the right of retribution. It has to be a unanimous decision.
That's right.
If even one person wants qisas, retribution, they get it. But so a lot of families, they have, you know, the one person, and in so many cases it was the woman, and many said to me, well, it's because she's the mother. And you know, we should say that a lot, like the gender of a lot of people who are killed is men. And so this sometimes leaves female figures like the mothers. The spouse cannot be, by the way, the spouse is not the intimate relative that doesn't have a right of qisas.
أولياء الدم, they
Awliya Dam.
yeah,
Technically in Arabic, it means the owners of the blood.
Yes.
Yeah, the custodians of the blood. So they can just determine what happens with the blood. And so, but we're not just talking about women, we're talking about gender. And so there is this process in which there's this very masculinization of the heroic process of forgiving on the one hand. You know, we have the pahlavan, and we also see in a lot of these stories the involvement of sort of athletes and, you know, notable celebrities, like very famous people, but also the people who often have to come to terms with whether they're willing to forego the right of retribution are mothers. And I ask, like, why her? And a lot of people I talked to, in many of the stories I have, they said, well, she's the one who gave birth and raised this child. And people said to me, and you know, the word mercy, rahm, shares a root with the word womb, rahim, in Arabic. And that was really surprising. I did not know that. And I talked to a lot of people about that, and this was always the case. But another reason why this process is so gendered is because, and this actually came up back when you were at University of Illinois, and you invited me to give a talk there.
Yes.
I'll never forget. This is how, you know, the books get written. Like, there was a wonderful question. You had a visiting scholar who was a judge from Ghana.
Yes.
And she said to me, a lot of the stories that you're telling, they're basically stories about domestic violence against women. And how is this a good thing that you know, a woman is a victim of sexual or domestic violence and verbal abuse, and then she kills her perpetrator, and then she might, you know, be executed. And there are cases like that. And so in a lot of these cases, gender plays this other role as well, of the gender of the perpetrator might be female, and there are many fewer perpetrators who are women. However, there are more cases where women are not granted forbearance and men are, in similar scenarios. And so there is this sense in which the gender of forbearance is feminine, but the heroic act is sometimes seen as masculine.
Yeah. Even in those banners that there is a banner in the book, you have the picture that it's about Javan Mardi, you know, that chivalry, and but this is the
chivalrous man, but yet these women.
I know, but it's mostly done by women. I mean, they could have said like Shirzan or like a lion, which is also part of it. But that's such a kind of an interesting twist there.
Exactly. I mean, people say that these are the sources of this in the Persian tradition, the pre-Islamic tradition. And there is one case in chapter 6 where a group of social workers go to the house of a mother whose son was killed by her daughter-in-law. So it's one of these scenarios where a mother has to forgive a daughter, so two women, and she is not sure what to do, and it's really trying to do right by the memory of her son. So a lot of it is, what would my son want? And she has children, she has sons and daughters who are also deciders in this case, and they've delegated to their mother, but she also has to figure out, you know, do right by them. And it's interesting because the social worker does, in trying to convince her to forego retribution, part of the activities, I guess, around forbearance work or forgiveness work is calling her Shirzan, a lioness who's protecting her cubs, right? So sometimes that comes up, but yeah, it's all the process is very gendered, and gender also relates to the constant reincorporation of these relational values around honor. And women come to sort of be the protectors of female honor in these cases. Like the book opens up with this first case where a woman, it's not clear if she died or was murdered by falling out of a 5-story balcony. And the parents come forward in that hearing, and it's the mother who talks and says, my daughter was an honorable girl, because the implication was that your daughter was loose and she was at this man's house and something happened. And so, and her decision, and again, it was the mother who was not willing to forego retribution because her daughter's honor was at stake. So this process also re-entrenches these ideas, not just about gender, but also about gendered honor.
Yeah. And that case also exemplifies, and many other cases that you mentioned, that it's kind of a difficult position for the defendants to defend themselves. Exactly. And walking a very tight rope of not portraying the victim in such a negative terms, because they want to sort of make sure that there is no empathy towards the victim in their defense. And then at the same time, if they go far in portraying a very negative picture of the victim, then they're jeopardizing the anticipation for forbearance, because then you're antagonizing the victim's family. But then that part also is so fascinating, that how people strategize to put up a defense for themselves without antagonizing the victims. And this is about honor, this is about good name of the person who was murdered. And I mean, along with so many other kind of paradoxical kind of moves that people make there, this is also a very important part of the story that that they have to do in their own defense.
It's a huge part of the story, and it's a big it's a big issue that emerges when they're testifying, because they have a civil legal system where the judges are inquisitorial judges, they're interrogative judges, right? So they're asking the questions and they're trying to draw out the story of what happened from each of the people called to speak. And so on the one hand, the defendant has to do everything he or she can to defend him or herself, but sometimes that defense has something to do with defending their own honor against the violence or dishonor of their ultimate victim. And as you said, if they lose their case, they are jeopardizing that, what you said, I loved how you said, the anticipatory need for the families, the victim of the family, giving them forbearance. And this is a place where the judges, and especially the social workers, do a lot of work to try to work things out between the families. And in one case that I talk about in the book, not the one with the girl who fell out of the balcony, but a different one where the girls were with their mother, two girls and their mother, responding to years, decades of violence and abuse, sexual violence. And they had evidence in the record for this, and they couldn't testify to it because there's certain norms in the court. The judges would have had to clear the courtroom and have an in-camera hearing, and they, for whatever reason, didn't want to do that. But it became evident that the reason they didn't want to do that was because the family of the victim was present. and they didn't want to have that in the public record. Journalists were present, I was there, because it would jeopardize the anticipatory need for forbearance. But it did come out, however limited, nevertheless. And this is in the book, that, I mean, procedurally, it was hearsay evidence. So even though it was very compelling and the judges found it compelling, it wasn't enough to undermine their confessions of what they had done. And so the judges came up with this very interesting way to get it out. What they said was, you know, this case has room for forbearance. And they turned, the chief judge turns to the victims, it was siblings, and said, you should read the affidavits and you'll see there's room for forgiveness in this case. And then this is the case where we were talking about, where they went from decision to, you know, handing down the ruling to immediately saying, let's have a mediation hearing here. And the judges said, you know, you don't have to do anything to the family of the victim. They said, and the family of the victim said, but they said those horrible things. They dishonored our brother. And they said, well, why don't you, and they turned to the perpetrators, his daughters, the daughters of the victim, and said, just say you did something wrong. And it was very vague, like, did something wrong in what way? Like by killing the guy, by making the testimony that they did and ruining the honor.
Yeah.
And he called over a journalist and said, just write that you did something wrong. And see, they said they were wrong, now you forgive them. And it was like, everybody was shocked. And it was actually in the next day's paper, a story. And I think I have the cartoon that is associated with the story where they're,
that's right. The two daughters are there and the mother is on the scaffold. And but I mean, it's a brilliant strategy because it's defending the honor in public. So that's achieved by the journalist writing it in public. And I also have to mention this, because I was talking about your book to a friend of mine, and they said, so like, how many cases are we talking about? I'm glad that there is a chart in the book, a table that we are talking about roughly between around like 55% of cases that the sentence is commuted and forgiveness works. So it's basically a substantial number of cases are successful in terms of forbearance.
Yeah.
And forgiveness works actually.
Yeah, I mean, one of the arguments in the book, by following these people and the social workers and the judges over a period of a decade, one thing that I noticed is that, and I talk about this in the later chapters, is that this forgiveness work actually works on the lawyers, the social workers, even the judges. And what I mean by that is, when I first started this project, most everyone I talked to said, oh, we're for the death penalty. You know, there's some people that they can't be rehabilitated, society can do without them. I only do this forgiveness work in the narrow category of Iran's responsibility to the Convention on the Rights of the Child. And over the years, I saw people saying, well, actually, I don't just work for underage people who are underage and have been convicted. I actually work in cases that just seem, it's just not right. And then over the years, people said to me, I'm 100% against the death penalty. So the same person in the book over the years went from being for the death penalty in most cases, except very exceptional cases, to completely anti-death penalty. And so this also speaks, the book also speaks to the question about legal reform. And you know, the politics in Iran around rights-based activism, which was my first project, also play in here. And we see how dangerous, literally, it is for people to be anti-death penalty activists in Iran, Atina Daimi, for instance, has a 10-year sentence because she's an anti-death penalty activist. There are others as well. But you have all these social workers, all these judges, all these people who are basically anti-death penalty activists, but they're working in this other vein through forgiveness. And, it does bring in my critique of mercy versus human rights. However, it is a process that carries with it what I call a self-fashioning that does affect the very people who are engaging in that work, forgiveness workers. And many people actually become forgiveness workers. So one story in the book in chapter 7 is about Hamid Ahmadi, who was on death row, and he was under age 18. And his case was very problematic, but the family of the victim was very staunchly in favor of execution, retribution for him. And his sister became very involved in his case, and to the point where she became a forgiveness worker going around the country on behalf of other people. And just a month ago, the family of Hamid's victim forewent retribution. They got a sum for damages that was collected privately, and he was released. So
yeah. So there is really so much. We can't really do justice to your book with a short conversation. And there are a lot of more questions I have, including your own access, which is such a sort of I know it is such a complicated issue to talk about access, but I think the book is an amazing evidence of the kind of careful ethnography that one can do in Iran, and through which you can open up different kind of possibilities, doors to the way the system works inside the country. Of course, as you mentioned, there are many lawyers, many social workers who really risk their own livelihood by doing this kind of work. We have a lot of examples of these lawyers. I'm glad that you talk about Nasrin Sotoudeh in the book, and one of the lawyers who's now on hunger strike in Iran. And she's been in prison for a number of years. But again, this is just the beginning of our conversation, and hopefully we can have you here at Princeton for another conversation, and maybe a seminar, workshop on these topics. And again, thank you so much for spending this time with us.
Thank you. It was my pleasure and really a treat. Thank you so much.
Thank you so much. So talk to you soon then.
Bye-bye.